This case opens with one of the most serious charges you can face without an immediate prison sentence. Burglary of a habitation, a second-degree felony carrying a potential to 20 years in prison. But instead of a trial, what you're about to watch is a high-stakes plea hearing, where every yes or no answer matters just as much as a verdict. Amanda Lynn Fious stands before the court asking for deferred adjudication, a legal lifeline that allows someone to avoid a conviction if they strictly follow the rules. The judge walks her through every right she's about to give up: jury trial, confrontation, silence, because once this plea is accepted, there's no rewinding the tape. And as the hearing unfolds, allegations of abuse, fear, and emotional volatility enter the courtroom, complicating what initially looked like a straightforward burglary case. The tension here isn't just legal, it's emotional. Was this a crime driven by fear, or a decision that crossed a dangerous line? And how much weight should the court give to explanations that arrive this late in the process?
Is retained on this one. I work for Monica Godetto. Ms. Fious, do I have permission to do this in front of Judge Boyd today?
Yes. All right. Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Fious, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State, we'll be proceeding on count 1, paragraph B. We will waive paragraph A.
Any
No.
objection?
No objection.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Oh, no contest.
You don't want to go to jury trial.
No.
You work the deal out with the state. You want the judge to follow the deal.
This is a critical legal checkpoint that viewers often misunderstand. Deferred adjudication is not a dismissal, and it's not probation in the traditional sense. The judge is very clear. If Amanda violates even one condition, the court can immediately find her guilty and sentence her anywhere within the full punishment range, up to 20 years in prison without a trial. That's why the judge repeatedly confirms competence, understanding, and voluntariness. The court must ensure this plea is airtight on the record. You'll notice how carefully the judge distinguishes between recommendations from the state and what the court is legally allowed to do. This is the justice system trying to balance mercy with accountability. And here's the engagement question. Would you accept deferred adjudication knowing one mistake could land you in prison for decades? Would you take your chances at trial?
To give up that right, or do you want to enter into this plea?
Enter into it.
All right. Court will find that, just 1 second. All right. Did you understand, if I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Fious, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargaining page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's to be no contact with Oscar Castro, Yemi, Vanessa Bayo, Mandragon, Jesus Leyva, and the address of... Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving...
This is where the courtroom energy noticeably shifts. Defense counsel introduces allegations of abuse and possible molestation, but crucially, admits there are no charges, no reports, and no evidence presented to the court. From a legal standpoint, that matters. Judges cannot sentence based on allegations alone, especially when they surface for the first time at sentencing. That's why the judge immediately asks pointed questions. Were charges filed? Was evidence presented? Has any other court addressed this? The answers are all no. This moment highlights a hard truth of courtroom proceedings: timing matters. Even serious claims lose legal weight if they aren't properly documented or brought before the court earlier. Emotionally compelling does not always equal legally actionable, and it raises a tough question for viewers. Should courts have more flexibility when abuse claims emerge late, or does that risk undermining due process?
Affirmative finding that's being requested in this case?
Per the code, this charge doesn't come with an affirmative finding, Your Honor.
All right.
It's for Title V offenses only, and burglary of habitation does not.
All right.
under
Well,
Title
I'll
V.
read the facts and we will see.
Yes, Your Honor.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. At this time, state offers into evidence its Exhibit 1 with all attachments.
No objection, Your Honor.
All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Our client's remorseful that this had happened. What's not in your the stipulations, not to your knowledge, is that there was some abuse, possible molestation from the complainant against her child, and that led to this event.
Well, have there been charges filed for that allegation?
Not to my knowledge, Your Honor.
Any evidence presented to anybody for that?
This is the first time I'm hearing about it.
Okay. All right. You may proceed.
The client is employed, self-employed, does meal prep. There's a $1,500 fine. However, she may not have consistent income. I know this is for 7 years. I was hoping that the fine could be probated.
This exchange is one of the most revealing moments in the entire hearing. The judge directly challenges the logic of the defense narrative. If you're afraid of someone, why go to their location? This isn't a lack of empathy, it's illegal. Reality check. Courts must evaluate behavior alongside claims of fear. The judge isn't denying that abuse may have occurred. She's questioning decision-making that escalated the situation. You can hear the frustration, but also concern, as the judge explores whether no contact orders existed and why they weren't enforced across courts. This is where overlapping jurisdictions, probation cases, and protective orders collide and sometimes fail the people involved. It's also where accountability re-enters the conversation. Fear explains emotions, but it doesn't erase criminal liability. What do you think? Should fear mitigate responsibility here, or was the judge right to draw a firm line?
Find where I was, and that night I was with my friends, and he was telling me that he was going to come looking for me and that he was going to find me. Anyways, it led on to the next morning. He was still contacting me. He told me he was there. I was telling him to leave me alone. Long story short, we ended up getting into it, over the phone. So I went over there to where he was at. And that's how I ended up there.
I don't understand that. I don't understand why you would go to a location.
Mm-hmm.
Your attorney is saying you're in fear of him, but you go to the location. And then did you see the photos?
Yes, ma'am. And he's currently out. He was guilty of putting his hands on my son and myself as well. He's out right now. I think deferred. I don't know. I couldn't tell you the legalities of that, but and that wasn't his only time. After I was arrested with this, he came to my house looking for me again with a gun and put it to my head. And because there was a restraining order, he had one on me. I ended up getting arrested. And so this is,
The sentence reflects a balancing act. 7 years of deferred adjudication, a $1,500 probated fine, strict no contact orders, mandatory courses, drug testing, employment verification, and 200 hours of community service, some of which can be reduced through program completion. This is not a light sentence. It's structured, restrictive, and heavily supervised. The judge also draws clear boundaries around employment, especially involving vulnerable populations. That's not punishment for punishment's sake, it's risk management. The court is saying, you're getting a chance, but we're watching closely. Deferred adjudication. Here is conditional mercy. One violation, and this entire case snaps back into felony conviction territory. The takeaway? Deferred adjudication can save your future, but only if you fully understand the weight of every condition attached to it.
Court is going to sentence you to 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact with Oscar Castro, Yemi, Vanessa, and Miss Abrams, that's Yemmi, Vanessa, Bello, Mondragon, Mondragon, Jesus Leva, Levya, and the BIPP course, TAP evaluation out of custody, follow recommendations. 200 hours community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours be deemed satisfied. The MRT course, once that's completed, 100 hours be deemed satisfied. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider.
This case ends without a conviction, but make no mistake, the consequences are real. Amanda Lynn Fious walks out with 7 years of deferred adjudication, strict supervision, and zero margin for error. The judge carefully separates emotion from evidence, acknowledges the complexity of abusive dynamics, and still holds firm on legal accountability. This hearing is a powerful reminder that plea deals are not shortcuts, they are binding agreements with serious long-term consequences. Deferred adjudication is an opportunity, not a guarantee. And communication with probation is emphasized as the key to survival. Under court supervision, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.